America was established with three separate branches of government, but over recent decades, the one branch that has become the most dominant, unquestionably, is the judiciary. They now make policies on every aspect of life, whether it's environmental, whether it is civil, whether it is criminal, whether it is religious liberty aspects. It's the Supreme Court that seems to have the final word on every aspect. And that really has not set very well with the American people. What we see is that in recent years, we're seeing now polling that says up to 3/4 of the American people think that judges have gone too far with what they do. The one branch that has become the most hostile to what we would call Judeo-Christian values, and rightly called Judeo-Christian values, has been the judiciary. We have yet to have a law passed in America by legislation that says abortion on demand's fine. That came from judges.
Right.
We have yet to have a law passed in America that says you can't pray at a football game. That came from judges.
Wow.
We have yet to have a law passed in America by any elected representative that says no Ten Commandments displayed anywhere. It came from judges. So much of what we have in the way of national policy didn't come from the people. It didn't come from the two branches closest to the people. It came from the branch most removed from the people.
Now, are those three branches equal?
The three branches we're told are equal. The Federalist Papers absolutely say they were not equal. You look at the Constitution, and when you read Article 1 of the Constitution on the legislature, Article 2 on the executive, and Article 3 on judiciary, Article 1 is the longest. It is Congress that has the most power, the most responsibilities, they're to do the most. Next longest of the three articles is the executive. There's a lot the president does, but the shortest of all the articles is judiciary. They're given very few things, very little jurisdiction. They're the one branch that was not connected directly to the people, so they're the one branch that was not given policy-making power.
Wow.
That was never in their assign at all. Never.
Now, modern day, they have really taken the front position in creating policy and creating the world we live in.
They've been allowed to take the front position. There's a reason that they did not do so for the first 160 years of the nation. The Federalist Papers themselves say that the legislative authority predominates, and they say the judicial authority is the weakest of all branches. They designed it that way because that's the one that people don't have control directly over, so that's got to be the weakest. This signer is Thomas McKean. He was one of America's leading legal authorities, and he was responsible for this 1792 commentary on the Constitution of the United States of America. Thomas McKean not only signed the Declaration of Independence, but he also helped author the Constitutions of Pennsylvania and of Delaware, and he served as governor in each of those states. Additionally, he was the Chief Justice of the Supreme Court of Pennsylvania. In the case Respublica versus John Roberts, a trial over which Chief Justice McKean presided, John Roberts was sentenced to death after a jury found him guilty of treason. And back then, a sentence of death meant that the prisoner had 7 to 10 days left on earth, not 15 to 20 years. After reporting the jury's decision and delivering the sentence, Chief Justice McKean then offered these words of wisdom and consolation to John Roberts.
The defendant approached the bench. You will probably have but a short time to live. Before you launch into eternity, it behooves you to improve the time that may be allowed you in this world. It behooves you most seriously to reflect upon your conduct, to repent of your evil deeds, to be incessant in prayers to the great and merciful God to forgive your manifold transgressions and sins, to teach you to rely upon the merit and passion of a dear Redeemer, and thereby to avoid those regions of sorrow, those doleful shades where peace and rest can never dwell, where even hope cannot enter. It behooves you to seek the fellowship, advice, and prayers of pious and good men, to be persistent at the throne of grace, and to learn the way that leadeth to happiness. May you, reflecting upon these things and pursuing the will of the great Father of light and life, be received into the company and society of angels and archangels, and the spirits of just men made perfect. And may you be qualified to enter into the joys of heaven, joys unspeakable and full of glory.
Signer of the Declaration, Thomas McKean, was another of our many founding fathers who was a strong Christian. When you look back to the original justices, I mean, we literally have signers of the Declaration We have founding fathers, we have individuals who wrote America's first legal commentaries that were judges. And you find that in their courtroom they were not hostile to Christianity or religion. You actually find folks like Thomas McKean, when someone was sentenced to death in his courtroom, he'd give an altar call. And we think, that's not appropriate for courts. Well, who told us that? Well, the last 30 years. This is a book from another very, very famous early judge. His name was Jacob Rush, Supreme Court of Pennsylvania. Interesting little section he has in here on this book. It's a address he gave on the sentence of death. This was in November of 1797. An individual had been sentenced to die. He said, "You've had a fair and impartial trial. The witnesses have been examined in your presence. You selected your own jury. You've been ably and zealously defended by your own counsel." So he's had all the due process, and the jury still found him guilty. So he's been sentenced to death for this murder. This is what the judge says. He says, "As you have but a short time to live in this world, and there's no hope of pardon from any earthly hand, let me urge you to seek a pardon from above." And he goes on through to tell him how to find that pardon from above, how to pray and what what God can do for him if he'll ask forgiveness. So there was not a hostility at all. As a matter of fact, you'll find that the folks like Charles Finney, who was a great revivalist in the Second Great Awakening, Charles Finney, born in 1792, Charles Finney made it real clear in his autobiography, he didn't want to be a minister. He wanted to be an attorney. So he entered the study of law. And in the study of law at that time, early America, he said that as he read his law books, when it gave the law, it also gave the Bible verse on which the law was based. He said in the process of reading his law books that he read so much of the Bible that he became a Christian by studying his law books. Now, that's not going to happen today. I mean, we're real hostile toward religious expressions. But you go into the original Supreme Court, they had prayer in the Supreme Court. They would not let a jury go out to deliberate until they brought a minister in to pray over the jury. The jury needs to get the mind of God on this verdict. We had prayer in the courtroom. We also had church services in the courtroom. The Supreme Court met inside the U.S. Capitol. It was regularly used as a church room every Sunday. The Supreme Court meets Monday through Saturday, and on Sunday it became a church room. We just did not, as a matter of fact, they had massive communion services in that room. Really, there was a communion service that lasted over 4 hours in that room. Now, I've been to some long church services in my life. I've never been to a 4-hour communion service.
Wow.
But you have that happening inside the court. So you have a lot of pro-religious faith. They're not hostile at all. That certainly has changed, but that was never the way it was designed. I mean, these guys were not there to make policy. Now, the court today has become the policy-making branch, but that was never the design of the Founding Fathers.
The rulings of our modern courtrooms bear little resemblance to the original intent of our Founding Fathers. What has affected this dramatic and historical change in our local and national courtrooms? And what is the responsibility and role of our nation's voting citizens in the judicial process? Discover our nation's godly history in the American Heritage Series. America, this is your heritage.
What we're really discussing is that really the judicial branch was not a co-equal in government. Is that the way that the originators, the
That's
original
exactly
intent?
what they said. That is exactly what they said. It is not a co-equal. They also called it a coordinate branch. That's the word they would use. That it was not a co-equal or a coordinate branch in government.
When did it switch over to being a co-equal branch?
It switched over when we, the American people, allowed them that position. We started buying into that. They started becoming very judicially active in the 1950s and 1960s. The Earl Warren Court is known for that judicial activism. They started intruding themselves into areas they had never been allowed to get into before. And there were actually hearings in Congress on impeaching the Supreme Court justices for that activism. And by the way, that's not a radical notion. That's something that we regularly did in American history. You look back at the Founding Fathers, they conducted a number of impeachment inquisitions, is what they call it today, but impeachments against judges for malfeasance. And it wasn't, see, today we have this thing that says, oh, you can only impeach a judge maybe for a criminal felony. Maybe you can impeach him. Back at the beginning, the Founding Fathers impeached judges for all sorts of reasons that were different, because the Constitution does not give judges a lifetime appointment. The Constitution says judges are appointed for the duration of, quote, good behavior. Wow. The bottom line is, as long as they act right, they can stay there. So what's it mean not to act right? If you will look at the original reasons that justices got thrown off the court, one got drunk in private life. Well, what's that have to do with what he did on the court? It doesn't matter. That was bad behavior for a judge, even if it's in private life. They impeached him, took him off the court.